Hierarchy of Law, a Foundational Treatise. 1. The Primacy of Natural Law. Natural law constitutes the supreme order of law, reflecting universal principles inherently aligned with human nature. Without adherence to these immutable maxims, the peace and stability of any society remain unattainable. Knowledge of natural law is accessible through reason alone and exists independently of its codification in positive law. 2. The emergence of commerce and the law of human interaction. The second order of law arises from human interaction concerning survival and relational conduct. Known as the law of commerce, it embodies the principle of treating others as one wishes to be treated. Originating over 6,000 years ago during the Sumerian and Babylonian eras, this law was codified through complex systems including receipts, coined money, shopping lists, and postal mechanisms. 3. The development of common law. Common law, derivative of commercial law, represents a further removal from natural law. Emerging from England and founded upon common sense concerning sovereign ownership of land, allodium, it gave rise to the jury system and judicial writs. These processes have since been absorbed and transformed into statutory rules and regulations. 4. The procedural foundation of common law. Under common law, individuals face their accusers or injured parties before witnesses to resolve disputes directly. Lawyers, attorneys, and judges, construed as representatives, were never intended to usurp this process, for representation is inherently a legal fiction incapable of embodying reality. 5. Legislative regulation and governmental overreach. The subsequent creation of governmental structures introduced legislative enactments ostensibly to regulate commerce within and between states. However, such enactments were never intended to govern sovereign individuals, only to facilitate the efficient flow of commerce. 6. Municipal governance and legal fictions. Beneath the structure of state and federal government exists a substratum of political garbage froth, municipal corporations such as United States, State of, County of, and City of. These entities regulate fictitious entities, e.g., John Doe, and not living sovereign beings. 7. Ascension to the sovereign's level. Citizens have been conditioned to interact with government entities on their fictional level. True remedy and lawful authority reside at the sovereign's level, rooted in natural and commercial law. Recognition of this reality constitutes the ultimate checkmate in the struggle for lawful self-governance. 8. The eternal nature of commerce law. Commerce law principles are immutable and eternal, expressed historically through sacred texts including the Bible. They have formed the underpinning of all organized human society for over 6,000 years and remain immune to legislative abrogation. 9. The role of the affidavit in commerce. Commerce in daily life is bound together through sworn oaths and affidavits, forming the contractual glue of the corporate body politic. Every act of application, registration, and certification constitutes a commercial affidavit, sworn under penalty of perjury. 10. Material evidence and ledgering. Every affidavit must be supported by material evidence, such as ledgering or bookkeeping, substantiating each assertion with verifiable facts. Commerce, antecedent to courts or government, sustains its authority through these practices alone. 11. The maxims of commercial law. The 10 maxims of commercial law form the inviolable foundation for all lawful interaction. They include principles such as the workman being worthy of his hire, equality before the law, the sovereignty of truth, the supremacy of affidavit testimony, and the requirement that unrebutted affidavits stand as judgment in commerce. 12. Affidavits as the supreme instrument of law. An unrebutted affidavit stands as truth and ultimately as judgment in commerce. Courts merely adjudicate contests between commercial affidavits. No judge or jury may overturn an unrebutted affidavit without inviting systemic collapse. 13. Sovereignty affirmed through commercial practice. Governments and courts exist only to adjudicate conflicts between affidavits. Sovereign individuals must assert their truths, bind others through affidavits, and resist unlawful governance through the superior forum of commercial law. 14. Commercial law and the Uniform Commercial Code, UCC. Modern commercial law operates through codifications such as the Uniform Commercial Code, UCC, and the Truth in Lending Act. These statutes represent the distilled principles of commercial interaction now applied globally. 15. Assessment and collection processes in commerce. The IRS's authority stems from collection, not lawful assessment. Commercial processes are non-judicial and operate independently of court procedures. Without a valid affidavit establishing a true bill, IRS assessments are legally defective. 16. Remedy through commercial affidavit and lien. By issuing an unrebutted commercial affidavit, individuals create lawful liens against defending agents. Subsequent filing of a UCC-1 financing statement secures priority interest. Remedy is achieved through either rebuttal, jury adjudication, or payment. 17. Involuntary bankruptcy and enforcement mechanisms. In the absence of rebuttal or settlement, enforcement follows through involuntary bankruptcy procedures. Title to property passes lawfully to the lienholder. Officials without valid bonds are rendered inoperative. 18. Conclusion, mastery of lawful authority. By invoking the foundational principles of natural and commercial law, sovereigns reclaim lawful authority over their lives. Ignorance no longer condemns them to servitude. Knowledge, correctly applied, ensures lawful dominion and remedy against unlawful governance.